Millions of Americans have joint bank accounts, and most of them have no idea what federal law actually says about who owns what, who's protected, and who's on the hook when things go wrong. Today, we're breaking down exactly how federal law protects joint account holders and where those protections quietly run out. Stick around, because by the end of this video, you'll know things about your own joint account that your bank will never sit you down and explain. Welcome back to Money Regulation Hub, the channel where we take confusing financial rules and turn them into something you can actually use. Today we're tackling joint bank accounts, checking accounts, savings accounts, or CDs owned by two or more people. Married couples use them. Parents add adult children to help manage finances. Business partners use them for shared expenses. But very few people understand the actual legal protections and risks baked into these accounts. By the end of this video, you'll understand 5 critical things. How FDIC insurance treats joint accounts. What happens to the money if one owner dies? What happens if one owner is sued or in debt? Your rights when the bank makes an error, and the biggest mistake people make when adding someone to an account. This isn't just trivia. This is the kind of information that can protect tens of thousands of dollars of your money. Let's get into it. Let's start with the protection most people have heard of but don't fully understand. FDIC insurance. The Federal Deposit Insurance Corporation insures deposits at member banks up to $250,000 per depositor, per insured bank, per ownership category. That phrase, ownership category, is where joint accounts get interesting. Here's the key rule. A joint account is its own ownership category, separate from individual accounts. So if you have $250,000 in your own individual savings account, and you also co-own a joint account with your spouse containing $500,000, that joint account isn't just insured up to $250,000. Zero in total. It's insured up to $250,000 per co-owner. With 2 owners, that's $500,000 of coverage on the joint account alone, fully separate from your individual account's coverage. Why does this matter in real life? Imagine a married couple. We'll call them Dan and Maria. They keep $200, zeros in Dan's individual account, $200,000 in Maria's individual account, and $400,000 in a joint account they both own. Because the joint account is a separate ownership category, and each of them is presumed to own an equal share, their combined coverage across all 3 accounts adds up to $800,000, even though it's all at the same bank. Without understanding this rule, a lot of couples either overworry that they're uninsured, or worse, don't realize when they've actually exceeded coverage limits by having too much spread only across individual accounts. The takeaway: federal law, through FDIC regulations, gives joint account holders meaningfully more insurance protection than if that same money sat in one person's name. This is where a lot of families get emotional, and where federal and state law intersect. Most joint bank accounts in the US are set up as joint accounts with right of survivorship, often abbreviated JTWRS. This means when one owner dies, the surviving owner automatically becomes the sole owner of the account. Instantly, without probate court, without a will being read, without lawyers. Why does this happen so fast? Because legally, each joint owner is considered to already own the entire account, not just half of it. Think of it less like splitting a pizza in half, and more like both people owning the whole pizza at the same time. When one owner is gone, the surviving owner already owned it all. There's nothing to transfer. This is enormously useful for spouses. It means a surviving spouse can access money for funeral costs, mortgage payments, and daily expenses immediately. No waiting weeks or months for a court to sort out an estate. But here's the catch that trips people up. This only applies if the account was actually set up with survivorship rights. Some accounts are structured differently, as tenants in common, where each owner's share becomes part of their individual estate when they die, and does go through probate. Banks are required under federal consumer protection guidance to disclose account ownership types, but plenty of customers never ask and just assume survivorship applies. If you're not sure how your account is titled, that's a phone call worth making today. Here's the part of this topic that keeps people up at night. What happens if your joint account co-owner gets sued, or owes money to creditors, or even the IRS? Generally, under US law, funds in a joint account are considered available to satisfy the debts of any owner on that account, because legally, each owner is presumed to have access to and control over the full balance. That means if your joint account partner has a court judgment against them, or unpaid taxes, creditors can potentially reach the full account, not just their half. This is one of the most misunderstood risks of joint accounts. Parents who add an adult child to their account just to help manage bills may not realize that if that adult child is later sued or has debt problems, some or all of the parent's own life savings could be exposed to garnishment. Now, federal law does provide some guardrails here. Certain federal benefit payments, like Social Security, VA benefits, and federal retirement benefits, receive special protection from garnishment under federal regulation, even when deposited into a joint account, as long as they can be properly traced to that source. Banks are required to run an automated review when a garnishment order arrives to identify protected federal benefit deposits from the prior 2 months and shield that portion. But outside of these protected benefit categories, joint account funds are generally fair game. This is exactly why financial advisors so often warn: don't add someone to your bank account casually. If you want someone to help manage your money without exposing your full account to their legal or financial troubles, a power of attorney arrangement is usually a much safer tool than joint ownership. Now, let's talk about day-to-day protection. What happens when there's an error, unauthorized transaction, or dispute on a joint account? Federal law here comes primarily from the Electronic Fund Transfer Act, enforced through what's known as Regulation E. This law governs electronic transactions, debit card charges, ATM withdrawals, online transfers, and similar activity. Under Regulation E, any owner on a joint account has the right to report unauthorized transactions and dispute errors, and the bank is required to investigate. If you notice a fraudulent charge, you generally need to report it promptly. The law gives you stronger protection the faster you act, and your liability for unauthorized use can increase the longer you wait to report it. The bank then typically has 10 business days to investigate, though this can extend in certain circumstances, during which they may be required to provisionally credit your account for the disputed amount. Here's an important nuance for joint accounts specifically. Since either owner typically has full authority over the account, a dispute gets more complicated if the unauthorized transaction was actually made by your co-owner rather than a stranger. Regulation E is built to protect against fraud from outside parties. It is not designed to referee arguments between two people who both legally own the same account. If your joint account partner spends money you disagree with, that's a personal or possibly legal dispute between the two of you, not bank fraud. One more federal protection worth knowing: Regulation CC, which governs how quickly banks must make deposited funds available to you. For joint accounts, this matters because whichever owner deposits a check, the bank must generally follow the same federal availability schedule, often making a portion of funds available the next business day, with larger or riskier deposits potentially held longer. Joint owners don't lose any of these timing protections just because more than one name is on the account. This becomes especially relevant when a joint account is used for shared household expenses, and one partner is depositing a paycheck that the other is counting on to cover rent or a mortgage payment that week. We've covered insurance, survivorship, debt exposure, fraud protection, and funds availability. Let's bring it together with the mistake financial counselors see constantly: adding someone to an account for convenience without understanding that it makes them a full legal owner. It's not temporary access. It's not just in case. The moment someone is added as a joint owner, they generally have equal legal rights to withdraw every dollar, and their creditors may have equal access to that money too. If your goal is simply to let someone help pay your bills or manage things if you become incapacitated, alternatives like a durable power of attorney, an authorized signer arrangement, or a payable on death designation often accomplish the same goal with far less risk. Let's lock in what we've learned today. Number 1, FDIC insurance treats joint accounts as a separate ownership category, which can significantly increase your total insured coverage compared to individual accounts alone. Number 2, most joint accounts come with right of survivorship, meaning the surviving owner automatically gets full ownership without probate, but always confirm this is how your account is actually titled. Number 3, joint account funds are generally exposed to the debts of any owner, with special protections mainly limited to certain federal benefit payments. Number 4, Regulation E gives you strong rights to dispute unauthorized transactions, but it doesn't referee disagreements between co-owners. Number 5, Regulation CC ensures funds availability timelines apply the same way regardless of how many names are on the account. And the big one: don't add someone to your bank account casually. A joint account is full legal ownership, not a favor. If this video helped clear up something that's honestly a little confusing and a little scary once you realize how much is at stake, do me a favor and hit that like button. It genuinely helps this channel grow and reach more people who need to hear this before they make a costly mistake. If you're new here, subscribe to Money Regulation Hub. We break down banking law, investing rules, and financial regulations every single week. In plain English, no jargon overload. Drop a comment below. Have you ever had a joint account and did anything on this list surprise you? I read every comment, and some of the best video topics on this channel have come straight from you. And if you know someone who just added their name to a parent's or partner's bank account without really thinking it through, share this video with them. It might save them a very expensive surprise. Next time, we're diving into a topic that trips up even experienced savers: how FDIC insurance limits actually work across multiple banks, multiple account types, and trust accounts, and the simple strategy some people use to insure over $1 million safely. You will not want to miss that one. See you in the next video.